All right.
Great. Well, okay. Good morning, everyone. And I want to thank everyone for attending. I hope everyone's doing well under the circumstances. We are all plugging away, doing the best we can to bring some normality to things. So I'm glad all of you are here, and hopefully you'll find things, the presentation beneficial. We have been doing a series of these. This is the latest in a series we've been doing not only every morning on Tuesdays at 10 o'clock, but in between as well. We've been trying to bring as much content as we possibly can during these very, very strange and challenging times. Just a housekeeping matter, we do take questions throughout the presentation, so feel free to ask any question at any time. We don't mind interrupting the presentation to answer a question. If you are going to ask a question, use the Q&A section. Do not use the chat section. With that, let me get started. We are here today with myself, Tom LaGreca, Executive Director, Medical Revenue Recovery at Callagy Law. James Greenspan is our Managing Attorney in Commercial Insurance, and he heads up our Commercial Insurance Group. And he has been doing an absolutely phenomenal job with his team. Our last presentation regarding commercial insurance had to do with the surprise bill legislation. Many of you might have been on that. This one is going to be a little bit different. And to set the tone for today's presentation, I would just like to say one or two things, and then it'll kind of put all of this in perspective. The natural tendency or the history of medical provider dealing with commercial insurance claims has been random, to say the least. And what do I mean by random? There are 5 different legal forms that exist for pursuing additional reimbursement in a commercial insurance setting. There's the surprise bill arbitration, which many of you have become familiar with in the last couple of years. There is ERISA at the federal level. There is something called, and I don't want to get into the, I'll get into the alphabet soup of the state.
You stole my line.
Oh, I'm sorry. Sorry about that. But there are 3 different forms at the state level. There's state health benefit plans, there's IHCAP, there is PICPA. James is going to get into the details of all of those, even though I hope he doesn't get too much into the details, because it will put all of us to sleep, including me and other attorneys. Let me just say, the random nature of how things have been treated in this space has nothing but disserved the medical community. And here's why I say that. The medical
Tom, who we putting to sleep out there, Tom? Who we putting to sleep out there? We didn't put anybody to sleep. No, I'm kidding. How you doing, Tom?
Hey, good morning, Sean.
Hey, Sean.
James, what's up? Hey, so listen, I just want to thank Tom and James and everybody for being on. This is Sean Callagy of Callagy Law. And we are we're committed to bringing community, ecosystem, acceleration, sharing in the space of telemedicine and beyond here on these calls. So thank you for the outstanding initiative. And for everybody, we're going to create more of a sense of community, questions, chat. And in the chat itself, please feel free to message and share how we can serve you better, what are your biggest fears and concerns, what are things that you're innovating, having go well. And, you know, Tom, James, Krista, if you can give people some feedback and all that, that would be outstanding. And also, I want to invite everybody to the huddles every morning at 8:30. If you're unfamiliar with what we're doing, all I challenge you to do is give us a week of the huddles. And it's about creating acceleration, but not merely for inspiration. We have incredible geniuses in the space of marketing and sales on every single day. People like Les Brown, arguably the greatest motivational speaker in history, or certainly one of the top, who was unbelievable on last week, talking about how to create your story and acceleration and public speaking engagements and structure them. We had the founder of Action Coaching on last Thursday. And this gentleman has over 1,000 franchises across the world in 70 countries, and everything is about innovating and scaling and growing. From the smallest of business owners, for how they got from 1 office to 2 offices or 1 employee to 2, to people that have hundreds and thousands of employees at scale. And at this time, it's grounding us not only in possibility, but literal how to, like how to. And just like in medicine, there's the how to of creating outcomes for patients. There's the how to in running your practice and dealing with the financial dynamics. And certainly for many, the crushing pressure, what's going on right now with Corona and beyond. So, thanks for that. It's unblindedhuddle.com every morning. And again, I invite you there, but don't come for a day, come for 5 days, 8:30 a.m. Eastern time, and tell me at the end of it, like call and tell Tom, be here, tell me, Sean Callagy, call me and tell me that it didn't do what I'm saying it's going to do. So that's what's present. Tom, what's present for you? Like what are you feeling most proud of and connected to about doing these telemedicine webinars for this awesome group of folks?
Just trying to provide a sense of normality to things. It's difficult. Everybody goes through ups and downs, I'm sure, like I do, where sometimes you just get very upset that the world has essentially stopped. So anything that can be done to kind of keep the world engaged with each other, I think is just a great thing. And that's what I'm trying to do here with James and the rest of the medical revenue recovery team.
Yeah. And the final point that I'll make for today, guys, is this. If you read Robert, and I'm not saying to read it because you'll get all you need to know about it from things we talk about, but Robert Cialdini wrote a New York Times bestseller, highly critically acclaimed, probably about 20 years ago, called Influence. And the book talks about not just conceptually how influence works, but in-depth psychological studies that had been done on hundreds of different topics, and assimilates them into the principles of how and why people are influenced. So I bring it up only for this limited perspective this morning. It's a dynamic called social proofing. That social proofing is the reason that some think that the people drank Kool-Aid and killed themselves with Jim Jones, and most of them did it voluntarily in a peaceful and orderly way. Social proofing is also why pilots crash planes at a much higher rate after well-publicized suicides, and the same reason why car accidents, so plane crashes and car accidents go up in regions where there's prominent suicides that are announced in addition to other suicide clusters being formulated. However, it's also the reason why people in crowds join together and home teams win more, right? It's about the normalization of activity and thinking. And so what we're doing here in the huddles at 8:30 in the morning and on this phenomenal call with Tom and that we're building, and it's like our call here in New Jersey medical world and beyond, we're normalizing a different type of behavior and thinking. And it's never based on what anybody says. It's based on what people are doing. And to like social proof myself in this dynamic, I was on 11 calls yesterday and did 11 speaking engagements with, I should say, Zoom calls, computer calls, with every different type of ecosystem imaginable. So I am not sharing with you to do something I'm not doing, and that's just me. The Callagy Law population and community was dramatically higher than that. So this is not just what we're saying, it's what we're doing. So don't just show up on these calls for the content. Also look at what we're doing and how that could benefit you, your patient base, your referral base, even bringing them into this, and creating dynamics that you work on together, because people are more open today to work together than they ever have been before, and they're more accessible. So with that, Tom, and everybody, have an amazing day. And the telemedicine stuff and other information you're getting is critically important, but also study what's happening to create your own leadership during this time. Thanks so much, Tom.
Great. Thank you, Sean.
Thanks, Sean.
Thanks, James.
Okay, so without belaboring the point too much, the random nature of how the medical community has proceeded with commercial insurance has led to a lot of issues. And what I mean by that is, because there are 5 different forms for dispute resolution in this arena, the medical community has treated all of these as one size fits all. So you'll have an appeal process that you go through, a first level appeal, a second level appeal. And because the medical community doesn't get the plans, or has not been good at getting the plans, they've been proceeding on an appeal with an appeal process that is not tied to what is actually required in the plans. And procedurally, there can be a big difference between something that's governed by ERISA, something that's governed by PICPA, something that's governed by IHCAP, something that's governed by the state health benefit plans. So a lot of this, the purpose of today's session is to kind of make you aware.
Did we just lose Tom? I think he faded out a little bit on my phone. I'm not sure, Krista or Mark.
Yeah.
Okay.
I'm gonna text him.
Okay. All right. So, I think sort of picking up on Tom's point.
Can you hear me?
Oh, hey, Tom. Yes.
Okay. Sorry about that, folks. But so it is really the plan that's going to give you everything you need to know about what the appropriate forum is and how your appeals should proceed and when it's time to pull the trigger and get into some sort of a legal setting. So having said that, I implore all of you to pay very close attention to the differences that James is going to highlight because they will affect your ability to seek in a legal forum greater reimbursement, which you inevitably will be entitled to in the circumstances of commercial insurance. So having said that, James, you can take it away.
All righty. Thank you, Tom. Yeah, just to briefly echo what Tom was saying, the 5 different forums that exist in New Jersey really do not lend themselves to a one-size-fits-all appeals process. I certainly understand why a medical provider or an office manager would want that, because it's easy to say, you get a denial, here's the template appeal we send out. You get another denial, here's our template second level appeal. And if we get paid, great. If we don't, we just kind of write it off at that point. But I think that is doing the office a disservice, particularly in these times when it's so critical to be able to go back and to get you as much meat on the bone as possible. I know that a very, very high percentage, 90% of the elective procedures in New Jersey at this point have been canceled. I spoke to one client yesterday who said she's seeing some signs maybe that some of the elective procedures are increasing. Either hospitals are beginning to become more accepting of them, or maybe the doctors are trying to schedule them and to see if there's some justification to have them. But one of the goals that we're having here is to help all of the offices, everybody on the line, understand the process to know which avenues they should be proceeding down in order to recover some additional money on claims that they've already performed, in the past 3 to 6 months. So today, again, we're going to be focusing on the fully funded plans in New Jersey. There's 3 particular areas we're going to be talking about today. State Health Benefits Program, PICPA, and the ICAP or IHCAP. And again, Tom mentioned that there's ERISA litigation is the 5th one, along with the out-of-network arbitration. So the ERISA is dealing with self-funded plans. The 3 programs that we're talking about today are all fully insured plans in the state of New Jersey. So one of the questions I get when I'm discussing this with providers is, well, what is a self-funded plan? What does that even mean? What is fully insured? And how do we tell the difference? So that's really the first thing we're going to go into today. So Krista, if you could jump ahead 1 slide, please. Thank you. So the first thing is, what is a self-funded plan? An example, I know that some of you are just on the telephone call, so I'm going to try to describe it a little bit. For those of you, hopefully it's a little bit self-explanatory. Basically, a self-funded plan is when a company is large enough that they have created sort of a slush fund, this medical trust fund, to finance medical procedures for their employees. So the example I give on the slide here is Coca-Cola. They've got hundreds and thousands, maybe tens of thousands of employees. So they are large enough that rather than paying a Horizon or an Aetna or a Cigna to maintain basically an insurance policy, what they do is Coca-Cola employees will all contribute individually into this giant trust fund. of $1 billion or more, depending on how large the company is. And when payment is necessary for a procedure, money will get taken out of the trust fund. So that's all well and good, but the problem is Coca-Cola is in the business of selling soda. They are not in the business of administrating medical claims. So what they do is they go out and they hire an administrator. Well, who knows how to administrate these claims? Typically, insurance companies like Horizon and Aetna, Cigna, United Healthcare. So what ends up happening is those major insurance companies sometimes will be the people actually funding the plans, and other times they will be the people merely administering the plans and doling out money from that slush fund. So Krista, jump ahead another one, please.
Sure. We also have a question from Jeffrey saying also, can you define those governing bodies? Don't know what they stand for.
Yes, Doc, we will be getting to that. Okay, so, oh, sorry, one back, Krista. So the fully insured plan, again, this is typically a smaller business with far fewer employees. So for this business, there's not enough employees to have them contribute into a giant slush fund. So instead, what they do is they basically buy an insurance policy from these large carriers. So here, Horizon, Aetna, Cigna, United, another one I occasionally see that's much smaller in New Jersey is Oscar or AmeriHealth. So those companies are actually then funding the risk. They are funding the payments. So you're going to pay the premium, and then they pay, based on their actuarial tables and everything. That's where they come up with the premiums, and then they're the ones actually footing the bill. All right, next slide. So in terms of how do I tell what is a self-funded plan and what is a fully insured plan, it can sometimes be difficult. It is often difficult, unfortunately, in the state of New Jersey. Krista, can you jump ahead, please? Thank you. So there are several different ways you can tell. Unfortunately, there's not a real easy method. The legislature has toyed with the idea, and part of the 2018 surprise bill law did address this, but we haven't really seen it hit yet. One would think it's just right on the insurance card, and sometimes it is. Sometimes the card will say self-funded or fully insured. Sometimes it'll identify, Horizon or Aetna as the administrator, that's the keyword you're looking for. If it's administrator, it signifies it's going to be a self-funded plan. If the card does not state it, some of the other ways, you can call the carrier, you can do an appeal and request it. If you get the plan itself, obviously it'll probably say in the first page or even maybe on the cover whether it's self-funded or fully insured. And the last ditch way of finding out is filing in one of these forums and looking at the carrier's response. Very often we get claims in the out-of-network, the surprise bill arbitration, we file it, and it's only at that point that someone like Cigna responds and says, no, wait a minute, this is a self-funded plan, it's not eligible. All right, Krista, can you jump ahead, please? Okay, so as Tom said, there's ERISA, and then there's the 4 fully insured forums. We addressed the out-of-network surprise bill stuff last week, and then the 3 we're going to be talking about today are IHCAP, PICPA, and State Health Benefits Program. And next slide, please. Okay, so IHCAP. It is defined, I know, as Tom said before, we're dealing with a lot of alphabet soup today. So I wanted to give the full title of each program. IHCAP is the Independent Health Care Appeals Program. And overwhelmingly, this is going to be dealing with medical necessity denials. This one is actually run directly through New Jersey's Department of Banking and Insurance, DOBI. You're actually filing it with them, and at that point, they're going to be sending it to an independent utilization review company or organization. So 90% of the time, probably, it's going to be dealing with medical necessity denials. Some of the other things it deals with are disputes over whether something's medically necessary versus cosmetic, the definition of a service, whether it is dental versus medical. If something gets denied as being experimental or investigational, that is also subject to the IHCAP, also pre-existing conditions. So it's generally got this medical necessity feel, or what type of service, is it dental, is it cosmetic, that kind of thing. And it's also important to state that these decisions are all binding on the carriers. So if you go through the motions, if you file it with the state and you win, it is binding at that point on the carrier. Krista, next slide, please. Okay, so what do you need to know? The first thing is that this is not sort of a shortcut where you can just blow through the carrier's appeals. You actually have to complete whatever carrier's particular internal appeals process. Typically, that's going to be both the first and second level, sometimes an external review depending on the carrier. I even one time had a telephonic conference with a two doctor and one nurse panel on an appeal before going through and filing with IHCAP. So the first thing is you have to timely complete it. So it's also not sort of a safety net where if an office is to untimely go through the appeals process or file an appeal too late, you can then try to save it by filing here. IHCAP will not accept that. The carrier will come up and say the provider did not appropriately complete the appeals process because their second level was out of time or whatever. So in that instance, IHCAP will not be accepting the appeal. The other thing is that unlike the surprise bill, you do need the patient's consent. This is a form that I have seen in many, many files over the years. This is something I think the provider community is probably well aware of already. I did include the link for that form in the PowerPoint. Just like last week, I will be sending the PowerPoint slides out. It's on Dobie's website, so you guys will be getting a copy of it. It also requires a specific appeal form. So this is not something you can just throw on the office's letterhead and draft an appeal. That is certainly something you can attach to their appeal form, but you do, again, need to fill out their specific appeal form. And then also a copy of the carrier's denials. You're probably going to have the initial denial and then first and second level denials as well. I would include everything because very often we see the carriers are actually changing their positions. I've seen the appeals and the denials and the bases sort of warp over time as different doctors are reviewing it. I've seen different reasons come up. So I would include everything when you're filing, but you do not need to include the medical records at that point. What happens is Dobie accepts it, they send it to that independent review organization, and then that organization contacts the provider and the carrier to say, hey, here's what we need. And it's at that later point where you would be submitting the medical records. Next slide, please.
James, can I interject something here?
Sure.
And what I'm going to interject highlights why it is so critical to understand that no one size does fit all in this context. So if you notice, James is not discussing things like carrier authorized representative forms or powers of attorney and those types of things, which as of late have become extremely important in an ERISA context. So things like things that are in the plans, like anti-assignment clauses, which may necessitate a power of attorney, or carrier authorized rep forms, which we have probably spoken to many of you about in the recent past. There, if you notice, James is not discussing any of those things. And that's because at the state level, you know, those things grow out of the federal legal and regulatory world, not the state world. So it is so important to understand what form you're dealing with, because it'll remove the necessity of obtaining some things, but it may elevate the necessity of obtaining some other things. So I just wanted to interject that.
Yeah, that is a really good point, Tom. You know, this stuff is complicated, unfortunately. I think that, you know, if any of you have ever been in a courthouse, very often the courthouses I've been in are this sort of Frankenstein monster of the original building and then the first annex and the second annex and the new building, and they've got all these different buildings sort of smushed together forming the courthouse. This medical recovery process in the state of New Jersey is very much like that. Each of these programs and processes was created by a different legislation to solve a different problem at a different time. They've got different timelines, they've got different forms, they've got different requirements, and they're all sort of smushed together. So as Tom was saying, lumping them under one umbrella would be a mistake, but also is probably going to result in some kind of error in terms of the form or the appeal or the consent. So that's why it's important to remember which path you are on when you're preserving or when you're going down a different road, seeking to get additional money on a file. So right now, again, we're in a fully insured plan that's written in the state of New Jersey, where you're dealing most likely with a medical necessity denial. Those are filed in the IHCAP program. And there you need the specific consent form, which we'll provide the link. It was on the slide and we'll send everything out afterwards. And you need a specific appeal form that you're filing with Dobie. So when I say appeal form now, I don't mean appeal to the carrier. I mean IHCAP filing form, essentially, that is going to get sent to Dobie. Krista, if you could go back one slide, please.
Oh, sure. James, there is a question. If you could just scroll up a little bit. It's from Jeffrey Jacobs.
Yeah, I saw that. That's essentially what Tom was addressing. Dr. Jacobs was talking about, you know, powers of attorney and things like that for ERISA plans. That's not exactly the subject of today's webinar, so I don't want to get too far off topic. You know, I'd be happy to address that with Dr. Jacobs offline.
Thank you.
And it will be the subject of an upcoming webinar. So consistent with us having a series of webinars on commercial insurance, I do believe our next one, perhaps next Tuesday at the same time, will be focused on ERISA. So we'll keep everybody posted on when the ERISA presentation will be.
Great. So just to finish up on IHCAP, essentially the independent organization, when they review, they can uphold the carrier's denial, overturn the carrier's denial, or modify it. They can change it around, they can uphold parts of it, that kind of thing, but they are not able to recommend a different course of treatment, some other services other than what the provider has recommended and the carrier has denied. Another thing here, you know, a lot of these we're going to get to have specific timelines and deadlines. The IHCAP does not. There's no post-service deadline for filing. So as long as you have timely completed the carrier's appeals process, there's no 60 or 90 or 180 day deadline in which you have to file an IHCAP appeal. Similarly, there's also no deadline as to how long they have in order to make their determination on medical necessity, but typically it's between 30 and 60 days. All right, next slide, please, Krista. That brings us to PICPA. This is, again, with the alphabet soup, the Program for Independent Claims Payment Arbitration. This was created in 2005 by the Health Claims Authorization, Processing, and Payment Act, also known as IHCAP. And I include that because I have several times been asked about IHCAP. Is it a different program? You know, some of the providers have found it and looked up what are their rights under that. Essentially, IHCAP is the enabling legislation that created PICPA. So for all intents and purposes, you can sort of forget IHCAP. It just authorized this particular program, PICPA, which is what we're addressing now. PICPA in the state of New Jersey, and again, sort of going back to the theme of today, now we're starting down a different path. So again, fully insured, written in the state of New Jersey. This is a PICPA claim. These are run by Maximus. That's the same administrating body that runs the out-of-network surprise bill legislation. Here, we're not talking about medical necessity denials. We're talking about administrative denials. So it's probably things like NCCI edits, bundling, the timeliness of things, essentially anything not medically necessary. So that's the denials portion of what PICPA covers. They also cover arbitrations when there have been payments. If there's a payment dispute, whether the payments were proper under the plan, under the contract terms, and under any applicable fee schedules. So sort of back in the day, I think when plans were better and you used to see a lot more UCR plans, PICPA was a very good forum for a provider to dispute UCR. Still today, if you get a plan, if you perform some kind of elective surgery, and I say elective because today, if you were to have like an emergency surgery and it was fully insured and written in the state of New Jersey, we would be in the thing we talked about last week, the out-of-network arbitrations. So sort of by default, we are in elective surgery world at this point. So if a patient has a very good plan that is a UCR-based plan and the provider does not like what the carrier has paid, you could theoretically take it to PICPA arbitration and dispute the UCR payment. Unfortunately, more often what we're likely to see is that it's kind of a bad plan, a crappy plan that's based on some kind of Medicare percentage. I've seen things as low as 105%, 200%, 250%, 350%. So if there's some kind of dispute as to the way that it would be paid under Medicare, pursuant to the terms of the plan, those can also be brought into the PICPA arbitration forum. And the last thing is whether interest was paid appropriately. They will also handle that. The interest rates being so low these days, I really can't imagine when and why a provider would choose arbitration for that unless there was some kind of bad blood perhaps between the carrier and the provider. But it is an option there. Maybe it's a large claim or something that was very, very old and it might be worth it. But just, I figured I'd throw it on there because it is part of the plan. And again, if Maximus under the PICPA program decides in the provider's favor, it's binding on the carrier. Next slide, please. All right, so what do you need to know? Unlike IHCAP, which only deals with, again, medical necessity denials, PICPA deals with payment denials, and the dispute has to be $1,000 or more. Now, you can aggregate claims here between a carrier and a covered person. So if there's a lot of ongoing treatment of smaller medical services, maybe chiro, office visits, injections, things like that, that would typically be small, or maybe there's some partial payments, you can aggregate them all together and file. The other example was by carrier and CPT code. So if you're seeing particular denials or particular underpayments, that sort of thing, you can aggregate those to get above that $1,000 threshold. It does specifically say on the website that other aggregation models are not acceptable. So I don't think you'll be able to get creative here, batching together multiple patients or families or people that were in an accident, or that kind of thing, or whatever other creative ideas are out there. You're not going to be able to aggregate claims like that.
James, I saw a question regarding out-of-state plans. So what happens jurisdictionally if the plan is an out-of-state plan?
So that is going to take us off of the path that we're on, meaning even if it's fully insured and written in the state of, let's say, Connecticut or New York, it is not eligible for any of the stuff that we're talking about today. Jurisdictionally, what that probably means is that if you wanted to pursue reimbursement there, you would most likely have to file in the state court of whatever state the plan is written in. We touched on this a little bit last week with the surprise bill law, where if it's, let's say, New York, if the plan is written in New York and the emergency services take place in New Jersey, unfortunately, that case is not eligible for either New Jersey's surprise bill arbitration or New York's surprise bill arbitration. It's kind of betwixt and between, probably knowing the governments the way we do and the legislation, in 10 or 20 years, there will be yet another program that deals with those that sort of fall in between. But as of today, you would most likely have to file in state court in that particular state. All right, hang on, let me just take another look here, have some more questions. Okay, yeah, that's what we just talked about. We had another question about challenging NCCI edits in the out-of-network surprise bill claims. You know, that's something you could probably do in the arbitration statement when you're filing it with Maximus in the surprise bill arbitrations. But as far as I know, you're not able to first go to PICPA to challenge the NCCI edits, get a determination there, and then file it with Maximus for the surprise bill arbitrations, because as you amply stated in the question, there's such a tight timeline. So I don't think you'd be able to do that. Getting back to PICPA, again, there's a specific appeal form. So remember, in IHCAP, you had the patient's consent form, and then you had a specific filing form. Under PICPA, there's actually a specific appeal form that must be sent to the carrier. Again, I have given you the link to it. It's on Dobie's website. We're going to be providing the slides afterwards, so it'll be right on there. And it's important to note that here is our first like hardcore deadline that we've come up to today. So I bolded it, I put it in red and underlined it. You have 90 days to appeal using that specific form, one of these things, to the carrier. After you get the denial, or I guess an appeal response, you can then use this specific PICPA appeal form within 90 days of receiving that and send it back to the carrier. The carrier has 30 days to respond, and once you get the carrier's response, you have 90 days from getting the carrier's response to the specific appeal form to then file with PICPA. So very tight timelines here. 90 days, it's certainly better than the surprise billing, which is only 30 days, but still, you know, I've definitely seen cases here where a provider later on tried to say, hey, you know what, let's go through PICPA, and sent this appeal form long after the 90-day period, and PICPA would not accept it, even though we had a response from the carrier and then tried to file within 90 days of that response. That initial appeal on that specific form has to be made within 90 days of receiving the adverse benefit determination. Next slide, please.
James, let me mention one thing. This might be a good point to mention this. So some of you may be saying to yourselves, well, when do you guys involved? You know, we want to do some of this ourselves, but given some of the tight time frames, you know, if we give it to you guys at a certain point, we may be paying you guys to do something that we could be doing ourselves. All of those are very legitimate questions, and it does get tricky. So what I like to suggest to providers, and all of you should just take this as some friendly advice. I like to think that the sweet spot is for the providers to do a first level appeal and to do it very, very quickly, okay? The second level appeal, I think, is something that may be better off being put in the hands of your attorney in this space, because I don't imagine you're going to get much success with a second level appeal if you didn't have success in the first level appeal. So you have to ask, what's the trade-off here? So, you know, we certainly don't want you to give us a claim where you can collect some piece of additional reimbursement on your own. That's something you should pursue. And why pay us a fee for something that you could, some additional money you can get yourself? So I always suggest to the providers, do the first level appeal. But as soon as you get that denial of your first level appeal, or even if you get some successful resolution on the first level appeal, the second level appeal is not really going to buy you much. And you'll be much more advantaged if the second level appeal is put in the hands of us or an attorney that you're using to make sure that the timeframes are met and that a more legal type of argument is going to be presented at the second level, which presumably would include the plan language, et cetera, so that I think it'll be the most beneficial for the provider to do the first level and for them to turn it over to a law firm right away after getting the first level appeal response. That's just my word for some friendly advice on what I think the optimal process should be for the medical provider. Go ahead, James.
Tom, excellent point. And it also makes me think that, nobody loves efficiency and processes more than I do. One word of caution, though, that first level appeal is probably your best shot at getting quick, reasonable payment to get the initial adverse determination overturned. So I would urge all providers to do as good a job as possible on that first level appeal, and to avoid the urge to just sort of do this template. This is the first level appeal we send out all the time. If you're specifically addressing the bases for the denial, I think you're going to stand a much better chance. I've seen cases where a denial says, hey, look, we're denying it based on our internal, procedures because we require these 6 things to be met. I know it's time consuming, but if you take the time to go through and say, look, all 6 of these things are met, the MRI does show a herniated disc. It is pressing on the nerve. The guy did have 6 weeks of physical therapy. He was treating with such and such a doctor based on my prescription of such and such a date, etc. I think you're going to stand a much better chance at either winning that first level of appeal, or down the line, you're setting yourself up for a much stronger case saying, look, I've been arguing this stuff for 6 months or a year. Here's all my backup. Here's their basis for denial. It's basically unfounded. I would say, so just don't make those first level appeals totally template as much as, believe me, I understand the urge. It is worth it to put some specific time into those. Just to quickly wrap up on the PICPA program, what do you need to file? You need a copy of that specific form that you sent. You need any of the exhibits or attachment, anything you sent with that form also needs to be submitted to PICPA, and then the carrier's response, if any. So if the carrier never responds, you have 90 days from when they were supposed to respond. If they do respond, you have 90 days from the day on which they respond, essentially. And then you're supposed to be getting the decisions within 30 days. And my experience lately with Maximus is that they are timely now these days with their decisions. All right, next slide, please, Krista.
James, we have a question from Erica. Question from Erica. She's asking if these appeals apply only to in-network providers.
Erica, no, they do not. This applies to all providers in the state of New Jersey, regardless of whether they're in network or out of network. I would think that, if you're in network and it's merely a reimbursement question, you should know what to expect in your reimbursement based on the contract that you have with the carrier. So, if you are not getting paid what your contract says, hopefully, presumably, you will be able to, have that addressed appropriately in a first level appeal where you say, listen, we did XYZ service and the contract says I'm supposed to get paid $100 and you paid me $60. So I want my other $40. Here's the contract, here's my appeal, and then you send that in. I guess theoretically you could take that dispute to PICPA because it does talk about terms of a contract or a fee schedule. But hopefully the carrier would do right by the provider and pay the appropriate amount. If you're talking about a denial for, say, medical necessity, it doesn't really matter whether you're in or out of network. You'll still be able to take advantage of that IHCAP medical necessity denial program. The last program we're going to talk about today is the State Health Benefits Plan. It also covers school employees. We get into everybody here. I just wanted to give a little bit of the history. 1961, it was initially passed. 1964, expanded, and then it got renamed in 1972. So I know this is one that not a lot of people have familiarity with, but it does cover about 10% of residents in the state of New Jersey. All right, next slide, please, Krista.
Can I add a clarifying point here?
Sure.
A general rule, we did state that the that the dichotomy between state and federal was self-funded at the federal level and fully funded or fully insured at the state level. That is generally true. There is an exception in that state health benefit plans technically are self-funded plans, but because they are self-funded by the state or by some entity of the state, they are state regulated and not federally regulated. So I just wanted to make that clarifying point in case people might think that state health benefit plans, because they're self-funded, were somehow regulated by the federal government, which they're not.
Yes, good point, Tom. So, at the beginning when Tom and Sean were talking about putting people to sleep, my suspicion is that the state health benefits program would be where it happens. This one is very complex. There are multiple levels. So I'm going to try to keep it sort of surface level and just, generally inform everyone of what the options are that are out there and kind of what they look like, rather than getting too much into the weeds, I hope. So first, in New Jersey, the state health benefits plan is administered by Horizon. And these you should be able to tell from the insurance card whether it is one of them. It's going to have that NJX prefix right there on the insurance card. There are two different tracks of appeals within the state health benefits program that actually kind of mirror the two we've talked about, the IHCAP and the PICPA. In New Jersey, the state health benefits plan also has two. They have a medical necessity and an administrative level of appeals. So first, we're going to talk about the medical necessity appeals. Again, you have to complete the carrier's two-level internal appeals process. And here, when I say the carrier, it means Horizon, because they are the administrator in New Jersey. Then the next one is an external review, which is a little bit of a misnomer because the external review actually is getting filed directly with Horizon. So it's kind of a third level back to Horizon. Then they're going to send it out to an independent review organization. And that sort of third level external appeal must be done within 4 months of receipt of the carrier's denial. Again, they're bold, red, underlined. Please be sure that you're aware of that 4-month time frame. If that external review fails, that's when you can do a commission appeal, which is essentially your 4th level appeal, but it's the first one that's going to go outside of Horizon. Next slide, please, Krista. Okay, so speaking about the commission appeals, and this is actually the stage where the administrative appeals and the medical necessity appeals will merge back together. So these commission appeals are the same for both the medical necessity and the administrative tracks within the state health benefits program. You're going to wind up together here on these commission appeals. So basically, you've got 1 year from the denial of that third level external review to file in front of the commission. You have to essentially say why, include all the documents, and at that point, there's an optional hearing in front of that commission. And you almost like a mini trial. It's a little bit informal, but you're in front of the whole commission. You bring all of the appeals, all of the denials, all the medical records, all your bases. You can actually show up in person, make your case to the commission, and hopefully at that point prevail. If, however, you still don't, there's yet another level. You can request at this point an administrative law review. So next slide, please, Krista. So at this point now, we're really talking about the 5th level of appeal, which is getting a little bit absurd. And I think that it's, at this point, it's probably already going to have been decided, but I wanted to be complete and thorough. So again here, 45 days of the in-person commission hearing denying your appeal, you can then request back to that commission that it go to an administrative law judge. Again, it's kind of like a mini trial. You're going to state your case to the administrative law judge, that judge is going to make a recommendation back to the commission that has already, at this point, denied your appeal. So again, it's a little bit like the NFL, where their commissioner both hands down the penalties and then hears appeals of these. I've always thought is a little ridiculous. Here, the commission is going to deny your appeal, allow you to go to an administrative law judge, and then that judge is merely making a recommendation back to the commission. So I don't know how often you're going to see things get overturned at this point. And if the commission denies the appeal at that point, you could, of course, appeal it to the Superior Court of New Jersey, but at that point, it would actually jump directly to the appellate division, for those of you that are interested. So I figured I would just include that point.
James, I'm just going to drop in here. There's a couple questions we have.
Sure.
We have, if you want to go in the chat and see, we have, what are your fees for the second level appeal? And then, since this appears to be a complicated with all the government bodies, why don't you offer a package deal where you do all the billing, all the appeals, and all the ARBs? I thought the state HBP opted into the New Jersey on mandate.
We actually, I could take a crack at least the second one there, James. We actually do pretty much have a standard, we have a pre-litigation rate and a post-litigation rate. So we actually do have the same across the board rate for commercial insurance claims. So whether it's ERISA or one of these forms, it's pretty much a pre-litigation percentage and a post-litigation percentage. So yeah, we do treat them all the same, at least in terms of the fee, to try to keep it as simple as possible. The deviation from that with commercial is the state ER arbitration process, which because we thought we could offer a more competitive rates there than the typical commercial insurance rates, because it is a very streamlined process. So we do offer a lower rate in the ER arbitration context, but we do have an across-the-board rate, whether it's state health benefit plans, ERISA, PICPA, or IHCAP.
Yep, thank you, Tom. Krista, next slide, please. So the next slide, while we're waiting for it to get pulled up now, so that was the medical necessity path down which we could proceed, which again is 2 internal levels, external appeal, but through Horizon, commission level appeal, administrative law judge. And then now the other path is the administrative appeals. It's the title of the entire path, so don't get it confused with administrative law judge. That's the judge at the very bottom of the medical necessity appeal path. Here we're talking about non-medical necessity appeals that the state calls administrative appeals. Krista, can we jump to the next slide, please? Thank you. Okay, so these are talking about the application of planned benefits. I pulled these examples right out of the sort of information packet. So if you're looking at visits beyond a particular limit, maybe it's physical therapy, if it's post-op, that's the kind of thing that comes to mind pretty frequently for me. A hearing aid for a maybe younger than usual person, 60-year-old in this case. So if you've got particular administrative denials that are kind of getting denied based on an across-the-board process, if you have a specific reason, this is the forum that you would bring it to. So here, again, there's 2 levels. You have 1 year after getting the carrier's adverse benefit determination. And then second level, you have, again, 1 year after getting the denial of the first level. And then you wind up at the commission level. So, you know, there's, again, level after level. You can keep going down the path until you get, hopefully, eventually you prevail. Krista, next slide, please. And that's essentially it. So if I could sort of just briefly review, you know, to echo what Tom was saying at the beginning, there's a lot of different paths down which you can proceed with your appeal. And it's really important that you know which one you're on. And unfortunately, by virtue of not knowing necessarily whether it's a self-funded or fully insured plan, or whether it's written in the state of New Jersey, it can be very hard to get started. So that's why, you know, that early slide about finding out which one is which is actually critically important. You know, is it on the insurance card? Can you call and find out from the carrier? Can you get it in some kind of appeal response? Because the sooner you determine what path you're on, the sooner you can figure out which process, which form, which appeal you need to be doing, and also what your timelines are. And some of them are pretty expansive, up to a year, and some of them are kind of tight, 45 days. So you really need to know which path you're going down. And if you know it's qualifying here as a fully insured New Jersey written plan, then you should, based on the denial, know which path you're going to go down. Is it medical necessity? Is it administrative? Or is it a state health benefits plan? In which case, you've also got your medical necessity or administrative paths. So it's all kind of broken up, but it's critically important to find out as early as possible in the process which path you're on.
Yeah, and an additive reason for that is because obtaining the plan also varies depending on what we're talking about. So if you're talking about an ERISA plan, you know, the best opportunity you have to obtain a copy of the plan is from the employer or the plan itself. And in fact, ERISA obligates them to produce the plan if the appropriate person requests it. The state health benefit plans, and correct me if I'm wrong, James, typically those plans can be obtained online, I think, because they are state employees. So the government, the state of New Jersey, typically will post the plans online in some way, shape, or form. If you're talking about a state-regulated plan, it's the carrier who is the insurer there, and it's the carrier that may be the best opportunity to get the plan at the state level. So even depending upon what forum you're in, there's really a different avenue or different person or entity to reach out to in order to get a copy of the plan. So it's another reason why it's good to know what space you're operating within, because it just creates all different parameters for you to succeed in. That's all.
Yep. So that's kind of it. I hope, I know this is quite a bit complicated and a lot of alphabet soup and acronyms and everything here. But you know, the point is, there basically is a path for everything, and it's not one size fits all. You know, again, we did not talk about powers of attorney today. We did not talk about anti-assignment clauses today. We're only dealing with patient consent forms and appeal forms and which forum you're supposed to be in based on the type of denial. So we'll get to some of that stuff later on, but you know, if you're in a fully insured New Jersey written plan, there's a lot of different options, and I think mostly they're pretty good. And the thing that I like most about these is that you get ultimate resolution. The thing that's so frustrating for me in a lot of the ERISA space in the pre-litigation context is that you can send appeal after appeal, but often until you file, you are not going to get any success with the carriers. So here, at least in the state of New Jersey, you're going to get a firm decision, usually within 30 days.
James, are you got muted there for a minute?
Yep, no, and that's it. That's as much. So I don't know if there are any more questions. Again, we will be providing these slides to everybody that signed up via email. So if there are any more questions in the chat or in the Q&A section, we'd be happy to take a look.
And let me, so do we have any more questions? Any questions from anyone?
Someone asked if we do initial billing for a provider's office.
No, we do not. We are not a billing service, and we can advise quite readily on what is happening in reimbursement in terms of arbitrators and in litigation and how all of the coding and billing requirements are being treated by arbiters. But we do not, we go out of our way not to give actual billing advice because we are not licensed coders. We are attorneys, so we can report on what's happening in the litigation setting, in the arbitration setting, but without really directly giving billing advice, although indirectly, billing could be impacted by what we have to offer. So.
Yeah, you know, there's other things that we can sort of address that are, you know, Medicare based. Very often I will see surgeries where the doctor's billed as co-surgeons and the carrier denies it for one reason or another. Often I'm able to go look up a code and see whether it's on the co-surgeon list. And sometimes it says it's not eligible, can only be billed as an assistant. You know, we can talk about things like MMR, multiple procedure reduction formulas, whether something is an add-on code, even whether or not there is an NCCI edit, or there's some bundling issues, you know, that kind of thing. But, you know, as Tom said, you know, I'm not able to look at an op report and say, this is how it should be billed. We can only talk about it in sort of a legal context, you know, and the rules and regs from there.
Yeah. Any other questions? Oh, looks like we might have another one.
We have two in the chat.
Oh, Tom, it looks like it's a workers' comp question where two surgeons performed a surgery, but one of the co-surgeons was not on the workers' comp list. So the claim is getting delayed.
Sure. Listen, I would keep pressing them to give you an EOB, whether they're going to pay or not pay. And I would suggest that as soon as you get that EOB, if you're not satisfied with it, you have us take a look at it. I'm happy to take a look. You know, there's many reasons why they delay and many reasons why they end up underpaying. So feel free to reach out to me. Send me an email. I think you probably received my email address from the invitation. So feel free to reach out. I'll be happy to take a look at it.
We have another question.
Yeah, it's from Leo. I would say, Leo, why don't you reach out directly to Tom after the call? Okay, there you go. Great. All right, thank you. All right, I'm not seeing any other questions. So with that being said, you know, everybody stay safe. We thank you again, medical providers, for all the great work you're doing, you know, putting yourselves and your families in harm's way. So we certainly thank you for that. We hope everyone is staying safe and healthy out there. It looks like hopefully we're starting to turn a little bit of a corner, flatten the curve, you know, and not get to anywhere where we don't want to be. So that being said, we will see everybody, I think, next Tuesday again at 10 a.m. We're going to do our next CI webinar. Tom, any last thoughts?
Yep. Let me just mention later in the week, this week, we will be having another webinar that will be focused on PIP and the latest developments in PIP. So our team a very illustrious team of PIP attorneys will be on. I think it will be Friday, but keep an eye out for another email from me announcing it. And as James, as you said, next Tuesday at 10 o'clock, we're going to be having an ERISA focused CI webinar. And then after that, there'll be others. So thank you all for joining us. We hope you found it beneficial, and please do your utmost to stay safe.
Hey, Tom, I just want to drop in and say one thing, that if everybody would like to join us tomorrow at 8:30 a.m. on the Unblinded Sales Mastery Huddle to hear from a bunch of rock stars in the space of living a purposeful life. We have marketing and growing your sales, and I've attached the link in the chat as well. So definitely check that out, everybody. And we will be sending that link out with the slides and the YouTube webinar as well.
Terrific.
So thank you all for joining us.
Alrighty, thanks everybody.
Thank you, guys. Thank you, Krista. Thank you, James. Bye, guys.